Perfeito. Boa tarde a todos e a todas. Sejam todos bem-vindos. Welcome to this edition of the UFMG Masterclass on International Human Rights Law, sponsored by the Brazilian branch of the International Law Association and the UFMG Graduate Program. This is our last international law activity of the year at UFMG, and we are very honored to have a very special guest to talk about the International Court of Justice and human rights recent trends. As you all know, the case law of the International Court of Justice has not always featured human rights issues, but in recent times, the question has appeared very frequently before the court. It seems that states that use the court are more and more interested in invoking human rights treaties or treaties that protect human rights in its content, giving them the court the opportunity to rule on this branch of international law. To clarify some of the points of this relationship between the court and human rights, we have the honor of being joined by Professor Serena Forlati, who is a full professor of international law at Università di Ferrara and a leading expert on the court. Professor Forlati holds various positions in international scientific societies, such as the European Society and the Italian Society of International Law, as well as acting as an expert in various capacities within the international organization. Her books, The International Court of Justice, an Arbitral Tribunal or a Judicial Body, is a classic in the field and should be read by every international lawyer or student who wants to understand more about the court. His other writings on the court, as well as his analysis on the court annually in the Italian Yearbook of International Law, are sources of many important reflections on international judicial activity and international procedural law. His first book on international responsibility and treaty law, which we are fortunate to have here in our library, is also a fundamental book in the field. If I may make a personal note, during my years in Italy, I had the honor of taking classes with Professor Forlati, participating alongside her in conferences, and also an important event of the Italian Society of International Law in Ferrara, that she was one of the responsibles for organizing. And I also follow her Morelli lectures in home, so it's a personal joy to be able to welcome Professor Forlati virtually today to close our semester, and we hope that she will be soon with us in person here in Belo Horizonte. Professor Forlati will speak for 20 to 30 minutes, and then we will have a great debate on this thought-provoking topic that raises many stimulating questions. Without further ado, thank you very much, Professor Forlati, for accepting this invitation. The floor is yours.
Thank you very much. It is my pleasure and my honor to give this lecture. And after the presentation, I feel a bit shy, but please don't believe everything that Professor Lima has said. Otherwise, you will be sorely deceived. I must say that in trying to prepare this lecture, I had some difficulties in finding the right target to condense in 20 minutes something that is actually very broad and would deserve lengthier discussions, at least in my perspective of a person that has been following the court's work. So before beginning, I would just like to make a disclaimer. I have chosen some cases and some issues to discuss with you, but please be aware that this can only be a partial survey of what the court has done and the issues it has dealt with in the several decades since it was established in 1945. This said, and let me see if I can manage to have Zoom work properly. Yes, Yeah, a very basic resume of the court's role. I'm sure you don't need this much, but maybe it's good for students to recall that the International Court of Justice is a principal judicial organ of the United Nations. It has both a contentious and advisory jurisdiction, and that, very importantly, only states can have ius standi, are entitled to appear before the court as parties in contentious cases, whereas international organizations can be involved in the submission to the court of request for advisory opinions. Specific organizations and specific organs of the UN have this competence. A final note, the court's jurisdiction is based on consent, and this applies also when very serious violations of human rights and other jus cogens rules are at stake. I know this is not necessary, but it's very important also to stress that the court, as an interstate court, has a rather peculiar role whenever human rights are at stake, because I am sure you're all very well know that states tend to shy away from human rights litigation. They usually and traditionally, also before regional courts, they tend maybe to support individual victims, to endorse their applications, especially if they're directed against states that are not themselves, of course. But they traditionally are fairly reluctant to engage in litigation as main parties whenever human rights breaches are at stake. So in this is an important point to make when we look at the court's case law in the area of international human rights law, and in trying to focus how and why this case law has evolved or is still evolving. What is the place for human rights in an interstate court? This is the main question I would like to focus on in this discussion with you. And I would start by quoting an excerpt from a contribution of Bruno Sima, former judge at the ICJ and also expert in human rights. It's drawn from a contribution of 2013. And in this contribution, Judge Sima highlighted that just as the development of human rights as a body of law at the global UN level took several decades to develop, also the role of the court as an interpreter and applier of human rights law unfolded gradually and in rather meandering ways. Why quoting Judge Sima? Because I think his analysis is very illuminating about how the court's role has evolved over time. And also because he was writing at a time where significant changes were beginning to occur, at least in my view. And it's also, this conference is also an opportunity to look at how things have evolved later. This is what I will try to do. And let's see if I can get to my next slide. Here, yes. Just by way of a side note, I put in here an excerpt from the judgments on the merits in the Congo versus Uganda case of 2005. It's an excerpt of the operative part of this very complex and very important judgment of the court, which is in fact the first pronouncement of the ICJ in its contentious function, where the court actually found that the state had infringed human rights law. So you see, the court was established in 1945, and its first pronouncement in a judgment as to the breaches of international human rights law came in 2005. Why so late? Wasn't there anything before this? And how has the court's case law developed later on? This is what I will try to discuss with you. So I have divided the court's experience with human rights in different phases. And I will try to first focus on the court's first 25 years from 1945 up to 1969. I will try to explain later why this choice, but the first phase is a phase where, again, I'm just working in big blocks, and there would be very many nuances, but mainly the court's contribution to international human rights law was offered via its advisory competence, its advisory function. There were some very important pronouncements of the court. I have highlighted just two. The first one is the advisory opinion on the international status of Southwest Africa. Of course, this is not a case, an advisory case, where the court was engaging directly with international human rights law, but it is very important to keep in mind that the court was dealing with the right of self-determination, basically, and the right of self-determination has a very close connection to international human rights law. It formed an important part of the court's case law in its first phase. And in this 1950 advisory opinion, the court had the opportunity to stress that when discussing Article 80 of the UN Charter, which has to do with the UN Trusteeship Council, the court took the opportunity to stress that Article 80 purports to safeguard not only the rights of states, but also the rights of the peoples of mandated territories. So this distinction between rights of states and rights of people is important because it forms an important step that will also help the court in construing its case law as regards international human rights law proper, if you do not want to consider self-determination as part and parcel of international human rights law. The second, and this is really a crucial turning point, not only for the court's case law, but in the way we also look at international human rights law more generally, is the advisory opinion of 1951 on the issue of the reservations to the Genocide Convention. The Genocide Convention will come up again and again in my discussion, but really the first keystone of that paved the way for developments later on of the court's approach to international human rights law is to be found in this advisory opinion, where the ICJ stressed the special character of the Genocide Convention. And I'm sure you are all familiar with this passage where the court highlighted that in such a convention, the contracting states do not have any interest of their own. They merely have one and all a common interest, namely the accomplishment of those high purposes, which are the raison d'etre of the convention, and also stressing that there is no reciprocity as at the basis of the convention. One cannot, and I quote again, one cannot speak of individual advantages or disadvantages to states or of a maintenance of a perfect contractual balance between rights and duties. So this approach to the interpretation of the Genocide Convention has paved the way for seeing the whole body of international human rights law as something that really bypasses the traditional reciprocity-based approach to international obligations that is part and parcel of classic international law. What about contentious jurisdiction? There is very little dealing with international human rights. Again, the core of the case is concerned self-determination, and I just need to mention Southwest Africa, a case concerning, again, the status of Southwest Africa, where, however, the court met a very serious debacle, that could be a term describing the way in which the international community received the judgment of 1966, where the court considered that the two applicant states, Ethiopia and Liberia, were not entitled to seek respect of the obligations stemming from the mandate that was binding South Africa, and thus denying the possibility for states that were not directly affected by breaches of the rights connected to self-determination to seek the court's pronouncements on issues connected to this topic. This judgment was received with a wide set of protests, especially by developing countries, and led to a very serious crisis in the relationship between the court and the community of states that it serves. So why am I quoting this? Because the court was very much aware of this disaster and sought to get to some, to change its approach and to make it very clear very soon that the approach was different from what could be perceived in this 1966 judgment. So we come to the court's second phase, what I could describe as a second phase, and really the watershed is the Barcelona Traction judgment of 1970, where the court developed the concept of obligations erga omnes. This is not a concept that only concerns international human rights law. In its famous paragraphs 32 and 33, the court gives other examples, but the first one are the rules concerning the basic rights of the human person, including the protection from slavery and racial discrimination. And the idea that these rights would be the concern of all states is enshrined in this passage. The court also highlighted that some of the corresponding rights of protection have entered into the body of general international law. Now, what exactly this meant was not really clear from the outset, and there has been a lot of discussion about the exact meaning of Barcelona Traction. It's what this notion of legal interest in the protection of rights corresponding to erga omnes obligations would entail. And in fact, the court took a rather long time to expressly deal with this matter again. If we look at how things developed in the later decades until 2012, we still see that there is a lot of emphasis on advisory opinions. I mean, advisory opinions are still often the venue where the court deals and manages to address issues connected to international human rights law. Southwest Africa, Namibia, advisory opinion, where the court stressed that there is a need for mandatory powers to respect human rights and fundamental freedoms for all without any distinction concerning having to do with race. Is an exemplary case, but also in 1996, the advisory opinion on the legality of the threat or use of nuclear weapons highlighted that the use of resort to nuclear weapons could imply breaches of international human rights law, and that the protection of human rights does not cease in times of war, and that even genocide could be committed through the use of nuclear weapons if the necessary intent could be proven, which is not, of course, obvious. Also, as regards the war in Palestine advisory opinion, there is a passage where the court highlights that the construction of the wall constituted a breach of various obligations under both international humanitarian law and international human rights instruments. But the court also had or was called upon to address some contentious direct the bulk of the cases in this phase, in this lapse of time.
I'm sorry, Professor Forlati, it's cutting a bit. It's only her, right?
Lapse of time I am analyzing. What did you lose?
No. Now it's okay. We are back.
Okay. I was just mentioning that there is a strand of cases beginning to come up. Basically, again, I am oversimplifying situations where the state of nationality of the assumed victims of human rights violations bring cases before the court. And of course, here we find a big hurdle, which has to do with the principle of consent. In many situations, even allegations of very grave breaches of international human rights law are not heard on the merits because of lack of the necessary consent by the respondent states. Still, some cases do get to the merits phase with different outcomes. I cannot analyze all these cases in a detailed way, but it's important to note that even when formally the object of the case is not necessarily formally connected to international human rights law, or where there is a lot of discussion about this, such as in the strand of cases concerning the Vienna Convention on Consular Relations, the court does read the guarantees set forth by Article 36 of the Vienna Convention in light of international human rights law. This is not necessarily so apparent in the first cases, but definitely very clear in the Jadaf case of 2019, which is a bit later than the time frame I identified, but I just wanted to highlight that the court read the obligation of reparation in the form of an obligation to provide effective review and reconsideration of judgments that had been issued in breach of the Vienna Convention, as having to encompass fully the guarantees connected to fair trial that are based on international human rights law. Just for reason of time, I will be quick. I would like to highlight that there are several cases, including pending cases, where states of nationality have brought the positions of their own nationals before the court, and that the court has, in the Diallo case, confirmed that diplomatic protection is a tool that can be used also as a way to implement international human rights law and to bring applications concerning breaches of international human rights law. This was not obvious. I will not dwell on this unless you have questions on this aspect. Another very important legacy of Diallo is the idea that whenever in this context states are awarded compensation for breaches of international human rights law, this compensation, the amounts paid or due, should go to the benefit of the direct victims rather than to the benefit of the applicant state as such. what we do see after 2012 is something quite new, not so much in the attitude of the court, but rather in the attitude of the states that appear before the court. And I would say, I agree with Judge Sima in this regard, that really a turning point is the case brought by Belgium against Senegal in the questions relating to the obligation to prosecute or extradite case. It's not the first case, contentious case dealing with erga omnes obligations, but it's the first case where really we have a state that takes up the cause of human rights, not in favor of its own nationals or not in a situation where there is a very, very close connection between its own nationals and the alleged breaches, but in a case where litigation is started in the common interest. I think you may be familiar with the case, which had to do with allegations of torture performed or ordered by a former head of state of Chad, who had taken refuge in Senegal, a party to the UN Convention Against Torture. Belgium, where several victims had moved after the end of the dictatorship in Chad, had started the case asking for the extradition to Belgium of Mr. Habré, who was the person accused of the commission of these acts of torture. And Senegal did not object to the Justandi of Belgium to bring this case before the court. The issue of Justandi was of the entitlement of Belgium to raise the case, to bring the case before the court, was, however, raised by the judges, and the court confirmed that the common interest that Barcelona Traction had mentioned, the common interest in respect of the Convention Against Torture, implies the entitlement of each state party to make a claim concerning the cessation of an alleged breach, but also to bring a case before the court. This is a very important case and has led to further developments. At a time where, if we look at the docket of the court a bit more than 10 years later, we see that human rights are often the object of applications. And also there are many cases where human rights are not formally or directly the object of claims, but there are clear indirect connection with international human rights law. The oldest case, one of the oldest cases, actually the oldest case pending before the court, Gabčíkovo, has to do with international environmental law, and some connections with international human rights are apparent, but also other cases have these indirect connections. Think only of the new advisory opinion, request for advisory opinion concerning the obligation of states in respect of climate change, or the right to strike under the ILO Convention, which is the latest request for an advisory opinion submitted to the court. So how has the framework changed in this last 10 years? You see the number of cases dealing with international human rights law. There are really human rights, a constant presence on the court's docket, be it in the exercise of its advisory function or in the exercise of its contentious function, both in terms of cases where diplomatic protection or sort of is at stake, and also in a by now small but constant thread of cases concerning with litigation in the general interest, so to speak, the Belgium versus Senegal type of situation. And what is also very interesting for me is to look at how litigation in the general interest is actually reshaping the courts and the state's approach to contentious proceedings and procedural fairness. So now I really get to the core of my presentation, but I felt I could not get here without the previous observations, which were necessarily rather quick. And I would like to refer here to another, I will then focus specifically on this litigation of in the common interest situation or scenario, where certainly a prominent place should be recognized or should be given to the case which was started by the Gambia in 2019 against Myanmar concerning the application of the Convention on the Prevention and Punishment of the Crime of Genocide. Yet another case concerning the crime of the Genocide Convention after the Advisory Opinion of 1951 and the genocide cases of the 90s, 2000, which I did not have the time to discuss in detail. Why this case is so important? Because once again, we have a situation where a state has no direct link to the crimes or breaches of the Genocide Convention. There is no specific prejudice for the state, but the applicant state acts really in the common interest. And in this situation, unlike Belgium versus Senegal, the respondent state, Myanmar, expressly raised an objection to the Gambia's entitlement to bring the case before the court, notwithstanding the erga omnes nature of the Genocide Convention. The court highlighted both in its order on provisional measures and in its judgment on preliminary objections of July 2022, that the erga omnes partes nature of the Genocide Convention implies the fact that other state parties to the Genocide Convention are entitled to invoke responsibility for breaches of the convention, irrespective of any specific interest or the nationality of the alleged victims. So this really seals the stance that the court took up in 1970, but it did not really have an opportunity to confirm seriously after that, because simply states did not raise the problem before the court. There is only one thing to highlight, namely the fact that one of the members of the court in Gambia, Myanmar, and also later, that is Judge Shwe, still very sternly considers that this is not an appropriate approach, but she's really the only one within the bench that is adopting a complete opposition to this approach, to erga omnes obligations and the procedural entitlements of the omnes in this context. Coming to the other aspect that I was referring to, procedural innovation. This approach of the court implies that there are situations where there could be participation by several states to the same proceedings. This is a rather unusual scenario. Traditionally, proceedings are very much conceived in a purely bilateral sort of civil procedure kind of approach, while the situation is quickly changing at the moment. And the other aspect that is worth highlighting is the fact that specifically in connection to this human rights litigation, the court has taken up a role of monitoring compliance with its own pronouncements, specifically provisional measures, that is also not typical for the ICJ. It is typical for other regional courts, but not for the ICJ. And I will get quickly to concluding. Specifically in Gambia versus Myanmar, the court has made use of an opportunity to impose on the respondent party, Myanmar, an obligation of reporting on the implementation of provisional measures while the litigation is pending. And this is something that is envisaged for provisional measures, but it's really a rather it's not obvious, it was not obvious, it was perceived as an important innovation. And the court has also modified its internal judicial practice to set up a committee for this kind of reporting obligations within provisional measures order were made in later cases, but the court has been not always keen on accepting this applicant state. The other aspect that is very, very important to highlight is the new, can we speak of a new trend? Maybe it is too soon to discuss a trend, but certainly there have been two situations, the Gambia versus Myanmar and the Ukraine versus Russian Federation cases, both contentious cases, where third parties decided to submit declarations of intervention under Article 63 of the court statute, the interpretative intervention, whenever the interpretation of a multilateral convention is at stake. States which are not the principal parties but are parties to the convention involved are entitled to submit a declaration of intervention. The court considered that the 32 out of the 33 declarations of intervention that had been submitted in Ukraine versus Russian Federation were admissible because they came from states which had ratified the Genocide Convention, also accepting Article 9 that implies the acceptance of the court's jurisdiction. And so these declarations were considered admissible already at the preliminary objections stage. Let's see what happens with the US declaration when it comes to the merits phase, we'll see. Also, as regards the Gambia versus Myanmar case, a few states have just announced on 15 November 23 that they intervene in the case. They wish to intervene in the case also under Article 63. Let's see also if the court's case law will develop on this issue, whether states will continue this trend of cases, using intervention as a tool to participate in cases concerning the common interest. But there is one last case I would like to refer to, another situation that is very similar to the Gambia, Myanmar and Belgium versus Senegal previously, started by Canada and the Netherlands against the Syrian Arab Republic concerning the Convention Against Torture. So another situation where a human rights treaty, the Convention Against Torture, including a jurisdictional clause, a compromissory clause, is brought before the court as in a case where the applicant states are not directly involved in any way with the victims, even less so possibly than the Gambia as regards the Rohingya population in Myanmar, which is of Muslim tradition as the Gambia. Here we don't even have this religious link that may explain the stance taken by Canada and the Netherlands. And again, the court in the provisional measures phase did not consider that there was any obstacle to this kind of common interest litigation, and identified and imposed some obligations in terms of provisional measures against Syria, which is not participating in the proceedings. Although not exactly the same obligations that the applicants had identified in their request for provisional measures. So by way of conclusion, I think that the current phase is a phase of change. It is too soon to say whether this change will become general or whether this new approach to human rights litigation will be confined to Western states or to a limited group of states. as the practice to date would seem to convey. Still, we are at the phase where the obstacles linked to the need to show a jurisdictional link can sometimes be overcome whenever human rights issues are at stake, and where the court is really proving itself up to date. It's taking up its role as a world court also in the area of human rights. And this is, however, also because states allow it to do so by bringing the right cases before the court. I think I will stop here. I will look forward to your questions, and I hope it was interesting for you to listen to this discussion. Thank you, Lucas.
Thank you very much, Professor Forlati, for this very thought-provoking presentation. I think that you offer us very much food for thought, and I know that we are probably going to have many questions. We have already some hands raised if you have questions. Perhaps, Professor Forlati, if you can end the presentation, would be better to see.
Yeah, I think, sorry.
No problem. But in any case, thank you very much. We have more or less 15 minutes. I have a question. I have many questions, but I will confine myself to one. I wonder whether, and my question relates to the procedural law of the court. I agree with you that there is this trend that states are using different procedural instruments now when it comes to human rights obligations and human rights treaties. And to a certain extent, we are seeing the procedure of the court being adapted to its new cases that states are bringing. And I agree with you, these are cases that are bringing, but at the same time, the court is adapting itself. My question to you is this: do you think that this adaptation on the procedural law of the course is due to the nature of the obligations and rights involved? Do you think that the reason why the court is adapting is because these are human rights and the court seems to be a little bit more sensitive, or only because the nature of the dispute and not necessarily the rights involved, or because they are human rights treaties that are being litigated before the court? What I mean, is the court taking into account the fact that there are rights to people protected from your perception, or this is something that seems to be business as usual since the clients are bringing new cases? What's your impression?
My impression is that the gravity of the allegation has a lot it has a significant role in explaining the court's approach. I think these are cases where the court cannot really afford to turn a blind eye. This is my personal perception. Of course, it is helped in this by the fact that Barcelona attraction is there, and that there were other cases, the whaling case, for instance, where it was not an issue of human rights, but the path was prepared, so to speak.
Yeah, it was there. It was there. So I'll give the floor to the student. Well, we have a lot of students here today, which it's explained either by your reputation and the success of the team. I normally don't have this much students during my class at this point of the semester. Rodrigo, you have the floor.
Thank you very much, Professor Forlati, for the very insightful lecture. I would like to dwell a bit more on the issue of remedies available for human rights under the ICJ. Because with the expansion of erga omnes partes litigation under certain human rights treaties, especially the disputes concerning systematic breaches on prohibitions such as the prohibition of genocide or racial discrimination. You mentioned the example of Gambia versus Myanmar and Azerbaijan versus Armenia. I would assume that the court would find new challenges on its way in order to guarantee effective reparation for these injuries. And you mentioned that in previous case law, the court had already found that reparation must be implemented in the benefit of individuals. So my question is, how do you see further development on the issue of reparations and the choice of remedies in this sort of litigation in the common interest, especially given the fact that Canada and the Netherlands have recently required remedies in benefit of individual subjects and not for the states itself under the Convention Against Torture? Is there perhaps a possibility that the court statute would be reformed to implement some sort of supervision of of compliance, something analogous to what happens in human rights courts, maybe. I'd like to hear your thoughts on that. So thank you very much again.
Thank you for this very interesting question with many levels. First of all, generally speaking, I think much depends on the kind of case. For instance, in the consular relations cases, the Vienna Convention on Consular Relations cases, there was no request, at least Lagrange, for instance, there was no request by Germany to pay compensation. The two Lagrange brothers were dead, and what was sought were guarantees of non-repetition rather than compensation. So I think the approach of states to this kind of litigation is very interesting. As to Canada and the Netherlands, well, the idea that you should ask, that states could ask reparation to the benefit of the beneficiaries of the obligation is something that is already enshrined in Article 48 of the 2001 Articles on State Responsibility. And I think states take the clue from that. But I think what is also very interesting is, or will be very interesting in the future, will be to look at how the court frames reparations. I think whenever specific reparation in kind is actually possible, that would be the preferred path, because it's that most conducive to effective respect for human rights. It's very interesting to look at how the court reacts when this is not possible. Congo versus Uganda, the compensation phase is illuminating in that respect. It was very difficult to get to, fixing an amount for compensation. My feeling is that by relying on equitable considerations of equity and so on, the court tried to convey the idea that there should be a meaningful reparation, but no. Convey the idea that there should be a meaningful reparation, but can you hear me?
Yes, now we're hearing you. It stopped a bit, but we heard the great part of your question, your answer, yeah.
So I was just referring to the fact that in Congo versus Uganda, the reparations case, the court, whenever it comes to compensation, is not really strict in identifying what exactly amounts to what. It rather goes to, it's not maybe so worth investing in a detailed analysis whenever there are these mass claims. So it also depends a lot on the kind of situation, whether specific individuals or mass situations is at stake.
Thank you, Professor Forlati. Perhaps we can gather more two questions, and otherwise we're not going to have, Fernanda and then Luisa.
Well, first of all, thank you, Professor Forlati, for your excellent presentation. I would like to know a little bit more, because when we talked about all those cases, it's usually regarding civil and political rights. And I would like to know more about the willingness, perhaps, of the court in regarding economic, social, and cultural rights. We have now environmental matters, which are close related to these rights, being the subject of an advisory opinion. And then I would like to know if these trends we are observing can be also applied to these other categories of rights, and how do you see the court position in regarding to these rights?
Thank you, Fernanda. May I gather Luisa's question?
Yeah, you're right, yes.
Yeah, Luisa, please.
Thank you, Professor, for your presentation. I wanted to ask you about the possible dialogue between, when it comes to human rights, the ICJ role and the role of specialized human rights bodies. Because, for example, in previous cases in the ICJ, such as the Diallo case that you mentioned, the court gave really great weight to the position of the Human Rights Committee. But in further cases, for example, the one between Qatar and the United Arab Emirates, the court already said that it is not obliged to follow completely the position of these specialized bodies who are non-judicial bodies. So I wanted to ask you how you perceive the possibility of this dialogue and how it will evolve, or if it will evolve with this development of the court's role dealing with human rights. Thank you.
Thank you, Luisa. Professor Forlati, if you want to take these, and then we see if you have time for Anna and the other questions, please.
Okay, I will try to be quick, but these are really difficult questions, and it's difficult to give a comprehensive or even tentative answer. Economic and social rights. I think the problem will be that the court, I don't see the court being flooded with cases concerning these rights, especially in its contentious capacity. If it will, I think it will take the approach that it took in Diallo to look at what regional human rights courts do in these cases, if they can deal when they have the competence to deal with economic and social and cultural rights, and look at the case law of UN monitoring bodies. I think I'm not thinking of an actual homologation. This is not what the court does, also to answer the second question, but it will certainly seek inspiration from that body of case law that is already existing. It will be a help for it in dealing with uncharted waters. Then how the approach to the justiciability of economic, social, and cultural rights, this is a big question mark, of course, but I don't think the court will shy away from, enforcing economic, social, and cultural rights. After all, the approach developed at the UN with the three-pronged component of any human rights, and the idea that there can be negative and positive obligations, or obligation to fulfill also as regards economic, social, and cultural rights, I think is something that is by now quite well consolidated and may help addressing the issue. So on the relationship with human rights bodies, yes, you are perfectly right. It's not a clear-cut path. The court has indicated that it will give with considerable weight to the pronouncement of human rights monitoring bodies, but it will also it has also highlighted that especially when these pronouncements are not well motivated, they are not supported by a strong reasoning, it feels free to disregard them. And this is exactly what happened in the Qatar case you were referring to. So I think consideration, but definitely not any feeling of being bound by their findings.
Thank you very much, Professor Forlati. I know that the time is quite cruel to us both in this moment, and we had many more questions here. I think that we have many hands raised, and perhaps this will be the theme for next year visit of your to Belo Horizonte. Perhaps you can find a way in your schedule to have you here. But I would like to thank you very much for your considerations. You offered us today a fantastic overview of what's happening in the court and raised many of the problems. And let's hope this is going to be a good trend on the court's case law, and that will not affect the court's legitimacy, as some are arguing that these cases perhaps can affect the court's perception that it's not a place to adjudicate this kind of disputes. But once again, I thank you very, very much for your time, for being here to present this beautiful conference and to answer some of our questions. Thank you very much, Professor Forlati.
Thank you all, and it has been a great pleasure. Thank you for thinking of me, and I look forward to further discussions.
Fantastic. So I end here, and thank you very much to all of you. Have a good weekend, and thank you once again, Professor Forlati. There are lots of clappings. Thank you very much. And we are then finishing this session. Thank you. Thank you all.
Thank you. Ciao.
Bye-bye.